Today's episode covers the basics of copyright law that most nonprofits need to know about. We answer the questions, who owns what? How does the owner protect their rights? Does the owner even want to? When can you use someone else's work? My guest today is my colleague and friend, Nate Garhart, an expert in intellectual property law here at Farella. Listen in. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella Braun Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Today, I'm really happy that my friend and colleague Nate Garhart joins us to talk about copyright law and especially the issues often encountered by nonprofits. Nate Garhart's practice centers on protecting and maximizing the value of various forms of intellectual property, which often represent important assets and major revenue sources for organizations ranging from startup ventures, public companies, and all the way to nonprofit organizations. Nate's work spans the gamut from selecting and registering trademarks to protecting and enforcing copyrights to strategic negotiation of licenses of all kinds. Nate also works with clients to minimize the legal risks related to their branding, advertising, and publicity strategies. Online, he counsels clients on internet issues and e-commerce topics, drafts website terms of use and privacy policies, and helps clients comply with Europe's GDPR and California's CCPA, and he reviews customer communications for compliance with current laws. Outside the office, Nate enjoys being in motion. He's a motorcyclist with a fondness for Ducatis, which he rides in the hills of the Bay Area. He's also a runner and a skier and serves as a member of the National Ski Patrol and as the legal advisor to the Eastern Sierra region of that organization. So, Nate, how's the forecast for snow this year?
You know, Cynthia, it looks like it's another La Nina year. I think that's our third in a row, and that usually doesn't translate to great snow. But as I found with most things weather-related, we'll see it when we get it.
That's right. You just wait and hope for the next weekend and play it by ear.
Exactly.
So let's talk about the overall IP landscape. As I was reading your bio, to me, that's just a huge array of issues. Can you give us some context and orientation for IP issues?
Yeah, great. We hear people talk about IP all the time, but what does IP really include? Well, it includes a couple of major areas. The first is patent protection, and that protects new inventions, useful inventions that companies and individuals come up with. The next area is trademark law. Trademark protects brands. So Nike, Xerox, Apple, those are all protected as identifiers of source of given goods and services for the owners of those trademarks. The third area is copyright, and that protects works of original expression. So that's things like books, very obviously, but it also covers a wide array of expression. So that might include music, dancing, various things that are recorded like films. So the only key with copyright is that the work has to be fixed in the medium of tangible expression. So that's straight out of the Copyright Act. But what does that mean? It means it can't be smoke signals. It can't be something ephemeral. It has to be recorded or fixed in some medium. So then outside of those big three, there are a couple of other areas that are kind of tangential but do fall under IP. And those would be, first of all, the right of publicity, which protects individuals' rights to use their own name and likeness for advertising and the like, and that's a state law concept. And then the second area is trade secret, which enables companies to protect those pieces of information that are strategic and important to the company that they keep secret. So those are the main areas, but today we are going to focus on copyright a little bit.
Yeah, so that's great. I see copyright come up a lot with nonprofits. Early on in my career, often it was curriculum for an educational program. Now it might more commonly be blog posts, things that they put on their website, artwork that they created. And we may not go into artwork in great detail, but it comes up a lot in the nonprofit sector. How it comes up, I guess we could start at the beginning. Creation. When is a work created? And when I create it, what do I have to do to protect it?
Great question. So it's very important. And as is obvious, the nonprofit itself isn't a person, isn't actually the physical creator of anything. It creates things through its employees and sometimes through third parties that it hires to do things, independent contractors. So the question first, let's look at employees. So when does the copyright come into existence? It comes into existence the moment that that work is fixed in that medium of tangible expression. So the minute that blog post is typed, the minute that curriculum is written down, once it's fixed, we'll talk about protecting it later and what that takes. But to answer the question of when it comes into being, right when it's created. For the purposes of our discussion, we want to talk about when and how can the organization be the owner of the work created by its individual creators, whether those be employees or independent contractors. So with employees, works created by employees within the scope of their employment are automatically owned by the entity. And the entity is seen as the author of those works. So the creator of those works, even though it can't physically create anything.
Quick question there. A lot of small nonprofits don't want to have technical employees. They treat everybody as an independent contractor to avoid complexity. Let's put it that way. Is that a dangerous operating model? How can you own the work if you're doing that?
First of all, let me say that, as you know, any organization should talk to an employment lawyer about hiring independent contractors and how to do so. But that aside, from the intellectual property perspective, you, the organization, certainly own works created by independent contractors. The issue with that is you have to do so properly through contract. So what I often see is I see an independent contractor agreement that says everything the contractor creates will be work made for hire, and it uses those words and says that because of that, the organization will own the copyright in those works. Well, that's actually not going to be effective, and it's a real problem, and organizations should avoid that language for the most part. Work made for hire is a specific term of art that is defined in the Copyright Act itself. And the Copyright Act says there are two places that you can have a work made for hire. The first is works of employees that are working or creating things within the scope of their employment. So going back to employees for 1 second, if an employee creates something within the scope of their employment, the organization owns it and is the creator under the law. On the other hand, if an employee, let's say me as an attorney for my employer, the firm, just one day because it's fun and I'm talking to people, I create a new theme song for the firm. The firm is going to have a theme song and I create it. Well, who owns the copyright in that? Well, I'm an employee of the firm, but composing theme songs, composing music is not within the scope of my employment.
Let's hope
so
not.
Even though, let's for all of our sakes. But if I were to write such a theme, even though I intended it to be for the firm's use, the firm would not own the copyright in that. I would. The firm would likely get an implied license to use that, but the firm would not be the owner of that. So it's key that the work is within the scope of employment.
And it can't stop you from singing it, so.
Nobody wants that, that's for sure. But let's go back to independent contractors and works made for hire there, because that's the second place. The Copyright Act says that a work can be a work made for hire when it's created by a third party under an agreement that A, says that it's a work made for hire, so check the box there. We're going on the basis that that was in the agreement. But the Copyright Act says that works made for hire only can be certain types of work. And it lists out specifically what those types of works are. There are things like contributions to a map, or a forward or a afterword to a book, things like that. The most classic is a contribution to a movie. And think about it. In a movie, you have lots of people creating things. You have the camera people that are recording things. You have the performers that are performing the script. You have the script writer. You have people that are recording the music or the dialogue. So you have lots of people adding in their creations in that case. And so the Copyright Act looks at that and says, look, we need to make sure that the film company owns the copyright in this whole thing. So that's where work made for hire makes sense. Most of the places that I see work made for hire used in independent contractor agreements by nonprofits and frankly most organizations do not fall under those listed categories. So that identification of them as works made for hire simply fails. At the end of the day, if they were pushed on it in some kind of court action or the like, it would likely be found that at best they have gotten an implied license to use these things, and they have not gotten ownership of these. And that can have big consequences. The other issue with it is California courts have specifically said if you use the words work made for hire, it endangers your classification of those people as independent contractors and non-employees. And so it's really language to be avoided. So what do you do instead? You have an assignment. You have it say that the independent contractor assigns everything that they create under the services that they're providing to the organization. And that's the proper way to get ownership in the organization and avoid that work made for hire language at all costs.
Oh, interesting. Okay. So that's a really key flag for contracts, because I also see that a lot of the contractors that provide this kind of content under contract, they have their own agreement, and their own agreement usually just has, I don't even notice the assignment language. It has the work made for hire buzzwords. So we want to look at their contract and say, is there a specific assignment in that agreement?
That's right. And the work made for hire law, often I will see that it's identified as a work made for hire, and then it says if it's deemed for any reason not to be a work made for hire, there's an assignment. And that's sufficient. The only concern there is with that California employment issue. But if the independent contractor is an entity rather than an individual, that's probably not much of a concern, because you're not worried about an entity claiming that it has any rights. On the other hand, if you're hiring an individual on an independent contractor basis, that would be a concern and could come to bite you later. So in those situations, I would avoid having that language in there at all.
Okay, so where do I register my copyright? Do I have to? How much does it cost? A couple of words on that. Any advice?
Absolutely. So again, I mentioned previously that copyright comes into being the minute you fix that work. So the minute you write it down, the minute you record it, the minute you type that blog post. That said, it's very difficult. And in fact, in order to enforce your rights in a copyright or a work covered by copyright, you have to have a registration. In order to get that registration, you have to file with the United States Copyright Office, and their website is copyright.gov. Pretty easy to find. The registration process isn't too difficult, and copyright.gov gives a lot of materials and resources to help you figure out how to do so, but it can be a little tricky. The place that it gets really tricky is with software. That's where I say if you were looking to register software, you should probably talk to a lawyer about making sure you dot all your I's, cross all your T's, and do everything that's involved, because there are a couple issues with software just really quickly. Most software is built with other people's software, and so you have to make sure you address those issues. Secondly, most software, by the time it gets to the point where you feel like, okay, we've got a product, it might be in its third or fourth version. And so you have to deal with the issues of having previous versions. So lots going on with software. Outside of software, it's usually not that difficult. But if it's confusing at all, I would suggest don't try to force your way through it. Just contact a lawyer to walk you through it or to take care of the registration. As far as costs, the costs at the Copyright Office itself are very low. I think last time that I actually saw the number, I think it was $45 per work. But I can't guarantee that that's the current cost. I haven't looked lately. but it's not very expensive. And compared to trademark or especially patent, it's very inexpensive, but very important. The other key about that registration is if you have a registration in place before an infringer infringes your rights, it gives you much better benefit. So you don't have to then prove up actual damages and can rely on statutory damages if somebody infringes your work. And secondly, it gives you the ability to recover your attorney's fees and costs from any infringer. And so having that registration in place before the infringement is very valuable. Now, if you haven't registered and you see an infringement and you want to take action in court, again, you'll have to have a registration. And here, if your registration is put into place after the infringement began, you'll still be able to get into court, but you won't have certain benefits, those that I just mentioned and others, that come from having the registration in place prior to the infringement taking place. So that's registration. It's pretty straightforward. Of course, any copyright lawyer would be happy to discuss any questions about copyright registration. The other topic that comes up in that protection area is notice. You see it all the time. Copyright 2022, company name, all rights reserved. Ubiquitous. I mean, it's pretty much early on every website you've ever looked at. So what is that and is it necessary? Well, it's not required. There's no requirement that you have a copyright notice. That said, there's a concept called innocent infringement where somebody would claim, I didn't know they were claiming rights in this. I didn't know anybody had rights in this. Well, you can overcome that a number of ways, but the easiest way to overcome that claim of innocent infringement is to point to the copyright notice that you have on that material. Well, sorry, but I have a copyright notice there, so you obviously were not an innocent infringer. So let's talk about what that copyright notice has in it. What makes up that copyright notice? First is the year. That's the year that the work was completed. So when you have a website, for example, it gets changed all the time. And so what you tend to see is a range of dates. Copyright 2019 to 2022, Farella Braun Martel, right? So it identifies any year in which there were changes made to that work should be included in the notice. The second piece of the notice is identifying the owner. Pretty straightforward. Using the corporate name, not a nickname or a DBA. I would suggest using the actual name of the entity. And then the third part that we see all the time is all rights reserved. That language used to be important because of some treaties around the world and certain laws around the world. That language isn't required anymore to be effective notice, but people are so used to it that when it's left off, sometimes there's a question of, well, they're not reserving all their rights clearly. That's not the case, but because it's so just accepted as part of the notice, I recommend just keeping it. It really doesn't have much of an effect other than kind of a psychological or unintended effect on those who don't necessarily know what the purpose of that language is.
So it's more of a flag to other people. Don't use my stuff.
Yeah, it's part of the whole notice is a flag, and that kind of is part of the flag that people expect.
So that's a good transition point to using other people's work. We've been talking about protecting our own work. When can we use someone else's work? And I know we'll get into licensing and open source and fair use, but I have to say, I saw an article this morning, a headline, and I'm guessing it's not fair use when you grab an internet sourced image, say of a tattoo, and use it on an album cover. Even I saw that and thought, oh, that's not fair. But anyway, I'll let you start into that group of topics at whatever entry point you want.
Sure. Let's start with fair use because we hear it all the time and we often hear it. I hear it especially from companies that I'm working with in the nonprofit sector that say, hey, we're nonprofit. We're not selling this. We're not making money off of this. We can copy it, right? That's fair use. And the answer, unfortunately, is often no, that's not fair use. So what is fair use? Fair use is when I copy something and I'm copying it not to do exactly what it did in the first place, but instead to do something else with it. And that something else has to be something that is in the public benefit, basically. So what basically the Supreme Court has said is, look, if you're copying things for another purpose, you have to be doing something like commenting on that thing. So you copy that picture and you put it up because you're doing a review of it or an insightful analysis of it, and you're commenting on it or providing scholarship about that image. That would be fair use. Copying it for another purpose, such as a tattoo, we could argue about it, but I would say does not comment on it or use it for anything other than to copy that picture into a different medium. The tattoo is just a different medium of the same picture. So very arguably, that's not fair use. And then I hear a lot, and most nonprofits aren't engaging in this, but I do get this question a lot. What about parodies? Parodies have to be protected, right? And the answer is yes. Parody is specifically protected because you are commenting on that original. But the problem is there's a lot of confusion between the difference between, and this simplifies it a lot, but parody and satire. So it's one thing to parody something and comment on that thing. It's another thing to provide satire by using something existing, but not simply commenting on that. So what's an example of that? Well, during the OJ trial, or after the OJ trial, there was a book that was published called The Cat Not in the Hat. And it was written in a very Dr. Seuss style. And it said things like, the gloves don't fit me, no they don't. The gloves won't fit me, no they won't. Things like that. And the court looking at that case said, no, that's not parody at all. That's satire, because what you're commenting on is the OJ trial and issues in the OJ trial and very important things, race and a murder case, lots of important things, but you weren't commenting on Dr. Seuss and you weren't commenting on The Cat in the Hat, which was the original work, the style of which was copied, and the materials, direct materials from that were copied. And so the court said that's satire, that's not parody, and that's not protected fair use. So fair use is a touchy area. I would say it's a very gray area. It's hard to define whether something is fair use without digging in deeply. So I wouldn't assume ever that just because the entity is a nonprofit, that any copying that it makes would amount to fair use and be protected as fair use.
Okay, so that leads to my next question as a nonprofit. All right, so I'm not sure if I can just use this. Isn't it easiest just to reach out to the actual creator and say, hey, I'm a nonprofit, will you license this to me? I suspect talking about the terms of a license agreement could take a whole other episode, but are there any key points about licensing that a nonprofit should watch out for? I guess this goes both ways. If they're asked to license their work, and on the flip side, if they want to license someone else's.
Yeah, so you're right. This could be a whole nother discussion. But just a couple of things. First of all, a license can be as simple as a permission. If you're looking to use somebody's image, they have a piece of art that they have put up that you'd like to copy from the web and put on your site because you like it, or a photograph or the like, because you think it's good for your website, for the background or something. Yes, you just request a license, and that can be as simple as a permission. Sure, go ahead and use it. Now, the more detailed that permission is, probably the better for you in the long run, because you'd want to know how long do you get to use it for? Is it forever? Do you pay any fee? Are others going to be allowed to use it? Or are you the only nonprofit or even only other entity that gets to use it? You can answer those kind of questions. And those on the flip side are the same questions that you would want to have answered and clear in any license that you provide to a third party for using your materials. So the answer to your question is yes, there's a lot that goes into a license, but especially if you are requesting permission from somebody else, depending on your use, you probably don't need that much. And so long as you get that basic permission, that's probably enough for you to move forward.
Somewhat related topic. I know in the early days of the internet, and I'm dating myself, there was a lot of question, well, if somebody published it on X, Y, or Z platform, that automatically makes it free for anybody to use. Is that sometimes the case or never the case now? If I see it on Instagram, can anybody copy that? Or do the terms that we've been talking about still apply to published photos, published works?
Generally, that's exactly right. The terms that we've been talking about, the requirements and the protections we've been talking about apply to those. And just because it's put out there does not give anybody the right to copy it. That said, when it's on a given website, that website may have terms of use. And boy, terms of use could be a whole nother discussion we could have. But that said, those terms of use may provide for licensing. It's something you have to look at. So it depends on the site. But if you're taking something, you do need to look for a license. And then I hear a lot, well, what if it's open source or copyleft? Then I don't need a license. Well, that's not actually true. Open source is licensed. It's licensed under an open source license. And we could talk about the terms, and that again could be another day of discussion. But open source licensing basically says you may use this and copy it and use it for other purposes identified in this open source license. But in order to do so, you have to satisfy the conditions that we provide. And those conditions might include providing attribution to the original owner or things like that. So again, you have to look at the license. And the same is true of what we generally hear referred to as copyleft licenses, which are really open source licenses for non-software products. So if you see something that's licensed under a copyleft license, again, you still have to look at that license and see what it requires to make sure you comply with the conditions of that license.
I guess two topics. One is user-generated content. If my nonprofit allows for people to add their own comments to my posts, how do we think about that? Maybe at that point, I definitely need an IP lawyer to look at what I'm doing in my terms of use. And I think that changes from time to time. So as a nonprofit, think about how to manage risks with user-generated content.
Great question. This comes up all the time. It can be as simple. Anytime you allow third parties, users, to comment or post anything on your site, there is the possibility that they would post something that infringes the rights of a third party. And so you have to be worried about it. Luckily, the law has provided a safe harbor to website operators that says for user-generated content, if you have a takedown procedure in place in your terms of use that explains how to provide notice that something is being infringed, something on your site is infringing somebody else's rights, and that you follow the takedown procedure and you take things down when you get that notice, and there's a whole procedure that goes on under it, that you will not be liable for the infringement arising from third parties posting things on your site. Now, this is all under the Digital Millennium Copyright Act. So the DMCA lays out a number of specific steps that you need to have in place, including but not limited to having your DMCA agent registered. But as long as you follow those steps, dot all the I's and cross all the T's, you'll be protected from liability arising from third parties posting things on your site.
Final topic, and again, I think this one is maybe partly covered in previous episodes that we did on insurance coverage. What's it like to try to get insurance for copyright infringement issues? Is that a thing, or is it impossible or very expensive? What's your experience on that?
Yeah, so my experience is pretty limited in the sense that, as you know, I'm not an insurance coverage attorney, but I talk to my clients very often about the minute they get, first of all, any kind of claim that there is infringement, any letter, any email that says, hey, you're infringing my rights, first thing I ask them to do is to tender that to their insurance company. Doesn't mean they have coverage for it, but you need to tender early. So as soon as you get that, I suggest sending it to the insurance company. Now, as far as whether you'll have coverage, it really varies, and you need to talk to your broker very specifically about that type of coverage and make sure that you have that kind of coverage in place if it's something that you think could be a concern for your entity. I would suggest it's worthwhile, and from my understanding, it doesn't necessarily have a large effect on your premiums, but you do have to call it out with your broker and make sure it's something that's covered under your policy.
So that's a really good point. We'll link in the show notes back to the episodes on insurance that may be useful to shed more light on that. Nate, I can't thank you enough for chatting with me today. This has been great. I hope to have you back on some of these topics. I'm guessing that terms of use, I can't tell you how often nonprofits, when we're talking about their startup and their website, they're like, well, I just copied terms of use from XYZ's site. And I don't know what they say, but they're all the same and I never read them anyway. I'm guessing you think that's probably a bad approach.
Usually a bad approach. You need to make sure that your terms of use actually reflect your policies on what you're doing and things that you're concerned about. So yeah, they're worth having a deeper look at. Also, in connection with that, your privacy policy. Those are the two main documents that govern, your relationship with people on your site. So yeah, you want to have your I's dotted and your T's crossed on both of those documents.
All right. So let's pencil it in to talk again, maybe in the new year, especially since I think some new rules take effect in January of 23. So hope to have you back and we'll continue the conversation on these topics. And we'll also put some links in the show notes to the site you said where we can find more information.
That's copyright.gov.
And any other websites or links that you can think of off the top of your head?
Off the top of my head, that's the one that I would turn to, but we'll add some things to the notes.
Thank you so much, Nate. It's been great talking to you today.
Thank you, Cynthia. I look forward to doing it again.
All right. That's all for this episode. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella Braun Martel. If you have suggestions for legal topics you would like for us to cover in future episodes, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. We upload new episodes most Mondays, so be sure to subscribe so you don't miss any. Thank you for joining us. Until next time, make a difference.